All right. Well, welcome everybody. Perfect timing for this topic right after Labor Day weekend, a few weeks ago, I guess now. But one of the biggest concerns people have after spending time at their family cabins or lake homes or hunting land, whatever it is after a Labor Day weekend, one of the biggest things that comes up is what do we do when we pass this down to everyone else? How do we deal with that? What's the right way to do it? And sometimes too, as people age, their concern is about protecting that for the next generation, whether that be from long-term care expenses or liabilities, whatever it might be. One of the biggest things with those types of properties, whether it's a cabin, cottage, hunting land, is how do you best deal with it? How do you pass that down to the next generation? Welcome again to our cabin, cottage, and family hunting land planning seminar or webinar, I should say. Like I said, it's a perfect topic after the holiday weekend a few weekends ago. A couple of things I want to mention before I go too in depth here. If you are registered to participate through Zoom, you do have the ability to ask me questions, and I will try to answer them as they come, or at least before the end of the webinar. So there is a Q&A chat box that you can submit those, and they will appear to me in real time. We also do have a fun event coming up on September 22nd. So I think that's next Tuesday. It's our Drive-In to Healthy Aging. We're partnering with Care Patrol for that. It's a drive-in movie at the Field of Scenes in Freedom, Wisconsin. So at 6:30, the gates open. It is free to register. You just have to register at healthyagingevent.com. And we will have a stand-up comedian who focuses on healthy aging. So that'll be fun. And then also the feature presentation of the film is the Secondhand Lions. It's Michael Caine, Robert Duvall, is it Haley Joel Osment? Is that his name? That kid. So it's a good movie. So come and join us if you're able. So main topic today is cabin planning, hunting land planning, lake home planning, all of that. Especially in Wisconsin, up north is relative, obviously, but everyone talks about their up north home, their up north property, up north hunting land, and how it's been in their family, or they want to keep it in their family for generations. But a lot of people don't understand that there's a lot of kind of intricate planning that goes into passing that on effectively and properly. It can definitely cause problems for the next generation or the generation after that if you don't go through the right planning mechanisms. And there's a variety of ways to do this properly. It just has to fit your situation. So, one of the biggest things we talk about with family cabin planning is, with like traditional estate planning. So how do we best do this? It's easy when we talk about, I want everything to go equally to my kids, right? That sounds very simple. It sounds like nothing can go wrong. So people pass it down to their 3, 4 kids, however many, in equal shares. And now that property may have 4 owners for the next generation. That sounds very simple, but a lot can go wrong with that. It's kind of the key issues you want to think about when you're talking about how is this going to work for the next generation is, okay, who, are they all equally obligated to pay those expenses now for property taxes, maintenance of, if it's a cabin, especially maintenance of the house on the land. What are the usage restrictions? Are there going to be any sort of disputes over, how often one sibling is using it over the other? Are there any liability concerns for them all owning this property in their own names, but maybe not living there all the time? So not really being able there to police it and make sure that nobody is, using it, for sort of inappropriate reasons. So there's sort of protection concerns you have for that as well. But one of the biggest issues I would say that comes up for people is what if somebody doesn't want it? What if somebody doesn't want to own that property anymore? Maybe they did initially, but now that they own it, maybe financially it's not working for them. They can't cover the expenses, or they just really don't want it anymore, or there's a sibling dispute and they really want out. That sounds like it would be simple, right? Sell your interest to somebody else. But where that issue comes up and you really run into a big problem is, okay, what if the other siblings can't pay them? What if they don't have the financial ability to buy their sibling out? Or if they're really having a bad relationship, what if they're just doing it out of spite, right? So your next step then is to seek outside of the family possibly, or some uninterested third party to purchase in as well. That's really hard to sell people on that. It's really hard to sell people on buying into basically, in my example, a 1/4 interest with family they don't know potentially, and that's a really hard sell. You're going to have a hard time having anybody be interested in that potentially without partitioning off if it's hunting land, but potentially. So those are certainly big concerns. And maybe it works for the first generation too. I mean, often it's the siblings grew up on this land or on going to the cabin every summer, all of that, and they get along well. But now what happens when they pass it on to the next generation? Are you having even more owners now? So if 4 turns into 12, now you've got it going so many different ways, it gets very difficult for people to manage that effectively. So possibly you want to look at putting ownership restrictions on it somehow of how that can be passed. How many owners are the maximum owners that you're allowing for it going forward, giving them a more effective way to deal with that. So there's a couple of different solutions for that, right? Obviously, if you're just looking at transferring it, through your estate plan, there's a couple of different ways to do that. If you're not, at all concerned about any of those things, which I would argue you still should be, even if you think it's going to work out. But there's obviously, and I should mention too, we have this handout we'll be sending you of kind of different planning solutions for that. So to kind of cover the first one, there's obviously deed transfers. So that's simply a document where you're saying, all right, now you're the owner. And that can be done whether a transfer during lifetime or as a transfer on death deed, something that then won't have to go through probate necessarily. So that's in terms of legal transfer wise, the simplest way to do it. But it doesn't necessarily mean you're going to get the best results. Simple does not always mean the best. Sometimes it does, certainly, but in this case, that opens it up to a lot of problems potentially if you are deeding it to multiple people. And now you have to deal with those ownership disputes potentially, or other financial issues that come up down the line. There's obviously family partnerships too. That's a pretty common planning tool. So that's where obviously you set up a controlling document to set out the rules of the family partnership agreement, and you say, all right, here's how the usage is set up. Here's if there's disputes over contributions to like the property taxes, here's how that's dealt with, and here's who can own the property. So that's one way as well to set up those rules. And kind of along those same lines is a limited liability company, an LLC. We often use those for family cabins. The big thing with that, making sure that you very intentionally set up the rules that you're passing down, because any new owner to that LLC that owns the cabin or the hunting land or whatever it is has to sign on to that, what's called an operating agreement that you've drafted. So you want to plan with that in mind, but an LLC operating agreement is a great way to say, all right, if somebody isn't paying their fair share of expenses, here's how we deal with that dispute. Here's how maybe ownership gets transferred at that point. If someone wants out, it is much easier to set up those rules of how somebody buys the other sibling out of their share of the LLC, rather than trying to find a third party buyer potentially. You can also have buy-sell agreements in place as well, along with that says if somebody does want out, here's we're agreeing on how to set the price for it. Maybe it's an appraisal. Maybe some people do this where they set a fixed price for it. I don't necessarily recommend that because it can have tax implications if somebody's trying to sell it down the road, if it's much lower than the fair market value of that property actually is. So that's a good option as well. The other option is using a trust. So if you're looking at voiding probate entirely, using a revocable trust is a very common tool to pass on family property to your children. That can be a good tool for a number of reasons, where you're saying, I want my trust to avoid probate, and here's how it divides up. But you can also provide some asset protection for that property for your kids, so that if somebody, one of your kids had creditor issues, for example, and their own property was at risk, their own finances were at risk, you can protect the land from those liabilities as well. It can protect it against divorces. You know, if you just give a home to somebody in their name, it's possible that it gets very easily commingled with marital property. And so if they get divorced, you're looking at possibly having that subject to some sort of division. Not necessarily, but it is possible. The other thing too is if you pass it down to your kids and there's long-term care concerns, that can also protect that from their long-term care concerns, as long as you set up their inheritance properly through that revocable trust. And I should say too that you know, an LLC versus a trust, it's really not either or. Sometimes that you use a combination of both. Often, actually, I would recommend using both an LLC and somebody's, you know, passing that LLC ownership through that trust. So it's kind of a tiered, you know, the LLC owns the cabin or the hunting land, the trust owns the LLC. So you can do it in a variety of ways and with a combination of a few of those options. They're not mutually exclusive. But the biggest things you definitely want to make sure are covered with any of those options. And quite frankly, one that a deed alone isn't really going to do for you, or, you know, TOD deed, transfer on death deed, won't do for you, is making sure there are ways to resolve disputes. You know, often these properties are set up or have been in families for generations, and it's kind of the one identifying thing that people always come back to, of remembering the fond times they had at the family cabin in the summer, or going out in the fall and going hunting on the hunting land. You don't want these properties to end up being a dividing factor in your family down the line. You know, very often when people own these properties together, what can happen is if there's ownership disputes down the line, or, you know, somebody isn't paying their fair share of expenses, that can drive a wedge between family members. So the best thing you can do is to make sure that you actually are, you know, not only keeping the family cabin in the family, but you're keeping the family together when you pass that family cabin down. You certainly don't want to, you know, necessarily just do what's the simplest in terms of, you know, legal documentation, but then potentially cause your family issues down the line with them not getting along or covering their fair share of expenses. The reason I mentioned limited liability companies as well is, and this is a good idea, I should say, for anybody who owns these properties to consider as a tool. It's not necessarily just as a way to pass it down. But when you have additional property, one of the biggest concerns is, you know, you're not always there, right? So what if somebody goes onto the property, you know, the classic slip and fall, right? Somebody slips and falls while you're not on the property, they sue you, and you own that property. Well, they can potentially, if it's not in an LLC, they can try to come back against all of your assets to recover against that. I'm not saying they necessarily would succeed in doing so, but it is a risk. So an LLC for a real estate like that, or a hunting land like that, can be a great tool to at least provide that buffer. So just to give some clarification on that as well, an LLC does not necessarily protect what is inside the LLC. So if it owns the cabin, it does not necessarily protect the cabin from liability concerns. What it does is it protects the rest of the owner's assets from the liabilities of that LLC. So if something happens on the hunting land and somebody gets hurt and it's negligence, they can't necessarily come against, you know, your own home, for example, or your bank accounts or things like that. But it provides that more liability protection for yourself than you would have otherwise. And that's also a great reason to use it for passing it down, because now you're adding more people and more potential visitors to that property, and just more points of contact where there could be more negligence, or, you know, something that goes wrong. And I do see I have a question about the long-term care concerns, and that's just getting to that. That is a big concern with people. Is okay, so I have, you know, however many assets. I have my home, I have this cabin or hunting land, my retirement accounts, all of that. How do I protect this so that I can pass it down to my children or to the next generation? What's the best way to stop long-term care costs from eating that up or forcing me to sell it to pay for long-term care expenses? And there's a variety of ways that we do that planning, combination of a couple of the tools I've mentioned. The one thing I can say you certainly don't want to do it's just generally not a good idea for protecting things from long-term care, is gifting the home to them outright, to your kids outright. Don't just transfer ownership to them, because it gets it out of your name, so you still potentially have it safe from your long-term care expenses, depending on how long ago you made that gift. But it does not protect it overall as much as you could with other tools. So to give you some background on that, when you're looking at Medicaid and what Medicaid counts as an available asset, or potentially if you are a veteran who served during a wartime period, maybe the VA's improved pension program is an option for you as well. They look at certain assets as exempt versus available. Generally, the primary home, especially if you're a married couple and one of you is still living in it, the primary home is exempt from care costs. They don't count it as an available asset, meaning they won't, if you have your home, they won't say, well, we won't provide assistance to you because you own that home. They won't force you to sell it necessarily. The same is not true for additional real estate. Both the VA and Medicaid only have those sorts of exemptions for primary residences. If you have additional real estate, it gets counted towards your available assets, which very likely means, depending on the value of the property or whether you're married or single, very likely means it's at risk. So people often try to say, well, let me just gift it to the kids. Let me get it out of my name, get it into their name, and we'll get it out of the way. So any sort of divestment like that you make for Medicaid, or to hide it from nursing home expenses, you have a 5-year look back period, meaning from the date that you apply to receive Medicaid assistance, they look back 5 years from that date and say, did you give anything away for less than fair market value? So you have to do that within 5, or hopefully with 5 years before you ever need care, so that you don't even have to think about it. But even if you protect it for that purpose, you're not protecting it from some other concerns and some other pretty big concerns that I would have for that property. So the biggest is, now that you've gifted that property to your kids, you potentially open it up to a number of issues. One, you lost control of that now. You don't own it anymore. So now your kids own it, and they could say, we don't want you to use it. Same goes for your own home, but this is true of family cabins as well and hunting land. They could prevent you from using it. The other is that it's not good tax planning. So when you purchase a piece of real estate, that is essentially what you would consider your cost basis in that property, meaning that when you turn around and sell it, how they factor what the taxable gain on it is potentially is the difference between what you bought it for and, if there's a gain on it, what it's sold for. So when you gift it to somebody, when you just transfer ownership, the IRS essentially says, well, we're going to say they bought it for what you did, however long ago that was. So if it passed down the family generation years ago, that could be very minimal compared to what today's value is. When you pass it to someone through your estate plan, whether that's a will or a trust or a TOD designation, what you're saying is you're adjusting that fair market value for them, or their cost basis to that fair market value for them. So if the home was worth, when I inherited, from one of my parents, if I got hunting land from them, if it today was worth $250,000, that's what the IRS would look at as my cost basis and say, well, that's if Justin turns around and sells that property, that's how we'll factor in that taxable gain. So that is a much better tax way to pass it on to them than to gift it, because potentially if they then need to sell it, you're looking at a lot of different people potentially having to pay those higher taxes, more taxes than they would otherwise. The other big concern with gifting property like that is now you are opening it up to anything that happens to them. So when something happens to a person, it happens to all the property they own, legally speaking. So if I got sued for something and didn't have it otherwise protected, that means that that property I own is also potentially at risk. So if you gift it to your kids outright and not using an LLC, not using a trust, something like that, well, if one of them gets sued, their portion of that ownership is potentially at risk as well. So you're not really protecting it as much as you might think just by gifting it over. So how we tend to deal with those long-term care concerns is a variety of tools. Like I said, LLCs are a good tool for protecting things from liability. But sometimes you use an LLC in combination with an irrevocable trust to get it out of your name, protect it from long-term care expenses, but also have some protections for yourself. Usage, you can maintain the usage over the property. If something happens to your kids as individuals, it doesn't happen to the trust that you put it in. So you're protecting it from their liability. And it can still be included in your estate when you pass away. So what that means is that it gets that tax adjustment and cost basis, so that if they need to turn around and sell it, they're getting the best tax treatment that they can out of it. So I hope that answered some of that question. Sometimes we use a combination of LLCs and irrevocable trusts. Sometimes we don't have the LLC. It depends on the individual circumstances, certainly. And I do just want to remind you all that if you do have questions, you have to click on the Q&A box on your screen, and then you can submit it there. I know it's not necessarily always the most direct thing to find. So another question I just received was, so I have a cabin and I am supposed to inherit with 3 siblings, but I want to keep the property and they want to sell. What can I do? I'm not sure I can afford it on my own. So that is one of the most common things we see come up where that's an issue. So the question becomes then is, it sounds like in this example anyway, you have not inherited yet. What you can do is you can get together, have family meetings. That's one of the first options, and talk about it. So if there is enough money in the estate potentially, and you're all supposed to inherit equally the estate, potentially that estate does not have to divide every asset equally. So they may be able to be compensated with other assets of the estate. If that's how that plan is set up, I'd have to see it to know for sure, but there are other ways. So for example, if I say all of my kids are getting everything equally, the residuary of my estate equally, then that does not mean everything I own is divided equally. It just means value-wise, everything is equal. So it's possible that they can elect to take other assets. You might not get as much liquid cash in that, that example. You might just get the home if there's just enough to cover it. But you then don't have to worry about buying your other siblings out in that event. The other option too, then, is if there's not enough other assets to pay it off, you can always then pay in the difference. So it might not be, it might not still be ideal where you're talking about, oh, I still now have to buy something from my siblings, but it would potentially be a lot less than you would if you were buying it like for fair market value. So it might make it more affordable. So that is one option. It's obviously not the most ideal, but especially if you know that they want to sell it or that they're not going to want to keep it themselves, it might be worth a discussion ahead of time to kind of figure that out, of saying, well, okay, here's talk with your parents too, obviously, on that, and say, well, here's what's this going to look like for us? We're just concerned about making sure this goes as smoothly as possible. It's one option, certainly. But the other option is, if it does pass down, you can look at the LLC option as a way to potentially set up some avenues of purchasing out over time. But that doesn't really solve your immediate concern of, they're going to want to sell it. It's not, an LLC is a great tool of saying, well, if somebody may want to sell it, you're providing some rules for that. But if they will, and you still know that you're not going to have enough, affordability is still a concern, you might want to have a family meeting on that as well. So there's a lot of different concerns that can come up with that. But especially if it sounds like you haven't inherited yet, that would be my suggestion, is at least having some sort of discussion first to get a better understanding of what this is going to look like. It's hard to know sometimes until it actually does happen what it's going to look like. But if you have that foresight and can talk with your parents and talk with your siblings about it, that can be good. Another question, what about owning hunting land and never having the land be sold? Must stay within a family member. Stay with a family member, no spouses, only family, siblings, and their offspring. That's a great question. So that's a big concern, right? And when that's something an LLC can cover as well, or different legal entities can cover, saying who is allowed to be an owner. We often do that with businesses, with LLCs too, but that same principle can apply to simple family property that you have in an LLC. The LLC can set up rules where it says, here's who is allowed to be an owner. This class of people can be an owner. You can even limit the number of owners so that there's no more than 4 people at any given time. So if you each have 4 kids, not all of the kids are going to be owners. So that prevents one issue of now you've got 30 owners at some point of this land, right? And you can put those restrictions on it. You can say, here's the class of people you're allowed to leave it to. So you can say it has to be a descendant of me, if you have enough descendants for that to make sense. You don't want to be too restrictive and then potentially have an issue of, well, now they have nobody to leave it to. But you have a lot of control as long as you're the one setting that up to say, here's the class of people that gets to have it. And you can expressly exclude spouses, which I often recommend doing, especially if it's a bunch of siblings owning it, because now you don't want to potentially have siblings owning it with, spouses, or maybe at some point ex-spouses. I mean, it could get really messy with that. So if you limit it to your descendants is one option, you can certainly say, well, okay, to my kids, then they leave it to their kids, or to only a certain number of their kids if you're trying to prevent ownership from kind of getting out of control with the number of owners. So you do have that ability. The one thing I would always caution, though, of being overly restrictive is it sounds good in theory sometimes, but when you actually come up with certain things that can go wrong, or real life events happen where they need to get rid of it, you don't want to prevent them from being able to sell it if they all agree on it, because now they're stuck with this property, and it could be a financial burden on them, and it might actually financially harm them if they're not allowed to get rid of it. So you do have the ability, though, to put rights of first refusal in there, saying it first has to be offered to so and so or to your descendants. But you don't want to say, after you've tried all of that, if you've tried all of that first, you don't want to say, I'm sorry, you can't sell it at all, because what might end up happening anyway is they can go to court and get that fixed anyway. So it doesn't do you any good. It puts more of a financial burden on them. But you can put restrictions on it within reason, I would say, of who that is allowed to go to, putting rights of first refusal on there. So, and that's often what we do in an LLC. If somebody is trying to get out of that ownership of the land, they first have to offer it to the other owners. And you want to make sure you have a reasonable way of determining value. You don't want to necessarily say, set it for such a high amount, but maybe make them get an appraisal, or if there's any sort of dispute over what that appraisal is, get another appraisal. You can put all of those terms in there to make sure that you're providing them with avenues. The one thing I wouldn't recommend is putting a very low value on there, or a set number necessarily of any kind. Because the same sort of tax issues might come up later of if that next owner then ever has to sell it, now they have a huge tax liability potentially. So if the land is worth, $1 million, I know that might be ridiculous depending on the size of the land, but maybe not. But then you say, well, it has to be sold to the new owner. The total value has to be, appraised at 200,000. Well, if somebody buys into that and then they turn around and sell it a few years later, they might have capital gains on, $800,000-$900,000 if the, fair market value is $1 million to 1.1. And that's just not providing them with good tools either. So I would say the fairest way to price that out is to have some sort of way of getting, an appraisal of what the fair market value is and saying how that is. I mean, maybe it's, hey, look at the tax bill as that. I mean, that tends to be a little low, so maybe that's not a good idea, but it's one option, certainly. The pricing disputes are where things come up the most. We have a couple minutes left here, so I do want to just remind everyone that we do have that drive-in next Tuesday on September 22nd. It's at 6:30 at the Field of Scenes, in Freedom, Wisconsin. It's the healthyagingevent.com if you would like to register for that. And our whole next couple of webinars we're doing are going to be about long-term care in particular. So I did talk a little bit about that today when it relates to family cabins, but our next couple of webinars are going to go more in depth for that type of planning in general for other assets as well, not just the family cabin. So that you can actually register for at estateplanninglive.com. And again, if you register through that, we'll often be able to send you materials to use, such as this, tools for protecting the cabin kind of chart that we have, as well as some of our books that we've written as well. And they're always at noon on Wednesdays. So, and our schedule for that is actually listed on that website if you look it up as well. You can always too, just one last thing is you can always set up an initial consult with us if you have any more questions or any of this brought up concerns. They are free initial consultations. We don't charge for them. So if you want to give our office a call, or we do website inquiries too. There's a lot of different ways you can get in contact with us, especially if any of this brought up concerns for you of how to deal with it. You have cabins and you want to figure out how best to pass it down to the family. We do this type of planning a lot, so we would certainly be happy to sit down and talk with you. Or we are currently doing a lot of webinar and phone or web chats and phone conferences as well for people who don't want to meet in person. So that is an option as well. But thank you guys so much for tuning in, I guess, and listening to me to chat at you for a little while. And one last question I got was the document emailed? If you signed up with your email, we do send them out via email. If you signed up and you didn't get it for whatever reason, you can certainly let us know. We can always get it to you. It will be I'm being told by Nicole, it will be emailed out right after the event. So if you haven't received it yet, that's why. Thank you guys so much. My pleasure talking to you guys. So if you have any questions, always give us a call.